esteemed guests here today. I request our secretary to welcome Advocate Arvind Raghavan to bring him on to the dais, please. Can we have a big round of applause for the first speaker here today? Please, sir. I request secretary to hand over a bouquet. It gives me immense pleasure to introduce today's first speaker, eminent speaker, founder of Arvind Raghavan and Associates, advocates, solicitors. He is a BCom graduate from Bangalore University, Bachelor of Law from Bangalore University, postgraduate diploma in Export and Import Management. His areas of specializations are as follows: due diligence on title relating to immovable property, documentation, legal opinions on various issues relating to properties, including litigations, structuring of real estate transactions and projects, and advising on tax implications, income tax, GST, and capital gains in relation to real estate transactions. He has been involved in the practice of property and related laws for the last 25 years. He has written several articles on immovable properties which have been published by professional institutes, chambers of commerce, other institutions, associations. He is a very renowned columnist in the Hindu with the column titled as Legal Chat and Fact File. He has published several papers in property journals, conducted workshops for the real estate sector. He was appointed by the Government of Karnataka Revenue Department as an advisor to help in the regulation, simplification, and transparency of land records in the state. Presently, he is the panel of Canara Bank, State Bank of India, and PNB Housing Finance Limited. He is also the legal advisor on property matters to various reputed companies and corporations. He is fully associated with NCS Raghavan & Co., Chartered Accountants, Bangalore, a very senior and reputed firm founded by his late father, Shri NCS Raghavan, and now his brother Ashok Raghavan is the senior partner of NCS Raghavan. He is also part of various other cultural and social platforms like Rotary, and he is also a member of the legal committee of Bangalore Club and KSCA. He served as a Honorable Secretary of the Karnataka Race Course Owners Association and Managing Committee of Bangalore Turf Club, and also acted as a government nominee, currently serving as a steward of Bangalore Turf Club Limited. He has an excellent verbal and written communication skills, delivered lectures in more than 300 seminars or workshops organized by various forums, especially on property matters, and published articles on property laws for several institutions. With this introduction, I once again present to you Mr. Advocate Ashok Raghavan, Arvind Raghavan. Welcome, you, sir.
Hello? Am I audible? Thank you. Good morning to one and all. Program coordinator, Mr. Vinay T., whose number I have stored in my mobile as Vinay-RERA, which I think is a better suffix for him than anything else, because he's an expert on RERA. Chairman Srinivas Hatti, Secretary Pramod Hegde, Treasurer Harloor, delegates and friends. It's a very exciting day for me today, because in the morning I will be discussing or I will be sharing my little knowledge with you on various principles of drafting and some critical clauses, which again requires you to read a lot of books like these. And in the afternoon, I'll be reading a book of another kind, because I also happen to be a steward of the Bangalore Turf Club in a lighter vein. So it's a very challenging day for me. That apart, this is a very emotional workshop or seminar, as I call, as far as our family is concerned. because my late father, NCS Raghavan, who passed away in 2017 after 57 years of practice, was a founder of the concept of a real estate seminar in the state of Karnataka, as you know. It was probably 1984-83 when we were just out of school. And we were, brother and me, were hounded by him every day. He used to write the article in the morning. We had to go to a letter press, make sure that the lettering was correct, get it printed, come back for proofreading, get fired, again go back the next day. We conducted workshops for 1 week each through a letter press technology those days, which is not a joke. Today you have your laptops, but where it helped us in perfecting our spelling. It helped us in perfecting the commas and full stops and colons and semicolons, which are so important. And moreover, it helped us understand each sentence because we were composing it physically on the letter press. See, that is the background, and I think my father must have conducted this kind of workshop for a week at a stretch for about 10 times for ICAI. And then my learned brother, twin, who's here, who's also former chairman of ICAI, he must have conducted as a program coordinator about 15 workshops. So we are associated with this workshop or seminar on real estate, if I can say, for more than 3 decades, as far as both of us are concerned. And many of you don't know, I also started my journey in life with an aspiration to be a chartered accountant. In 1982, I was the secretary of SICASA, but I ended up being a chartered accountant because the exam was too tough for me. So I took the easy way out. I became an advocate, and I started my practice in documentation because my late father was known for his skills in both documentation as well as auditing. So I took one branch and my brother took the other. Today we share an office, and like I said, I'm so proud with ICAI because without batting an eyelid, I can say ICAI conducts these meaningful workshops, whereas our own bar association has found wanting in this regard. And I'm also happy to note, one of my colleagues said, I saw the program list, it's filled with CAs, how come no advocates? I said, obviously because we advocates don't know the last T, which is taxation. My father is always to say the concept of 5 T's. Transferor, transferee, title, transfer and taxation. The first 4 T's we advocates know, the 5th we don't know. Chartered accountants know the 5th T and not the first 4 T's. So essentially, it is a requirement today that you need to have a tax knowledge to be to structure a transaction in real estate law. It is extremely important, so I'm so happy that chartered accountants have taken a lead, although it is obviously hurting my stomach. But end of the day, since I come from that background, and I think in our family itself we have about 50 chartered accountants practicing. And in our office, I must have seen about at least 2,000 interning and about 1,000 who have graduated as chartered accountants. So I'm emotionally connected with the chartered accountant, although I'm not one. Anyway, that apart, as far as the subject is concerned, I want to start on a lighter note. It's about two young colleagues in the bar who had just passed out and they started their practice in law. So they were debating over a cup of coffee about the 2 epics, the Mahabharata and the Ramayana. So one of them said, I always prefer the Mahabharata because I love civil law. I prefer it to criminal law. As far as I'm concerned, the Mahabharata is a simple land dispute case. The other said, no, I prefer the Ramayana. I love criminal law because what is Ramayana? After all, it's about a kidnapping case. So we advocates know how to simplify such huge epics into short sentences or short 2 or 3 words to describe epics like of that nature. However, few and far between as far as real estate is concerned. Radish was here, and I've always said, and I continue to say this, there is a lot of buoyancy in the market. So I am sure all of you are getting a lot of work in, especially after your GST and your capital gains issues triggered in on the real estate transactions. But I always fear on account of 3 factors, which I have repeated. I see I would not say it's going to be a crash, but I always look at a correction happening in the market for three common sense factors. Factor number one, the farmer has suddenly discovered the word square feet in his vocabulary and has forgotten the word acre. Factor number two, advocates like me and others are preferring to be brokers. Factor number three, brokers are becoming builders. All three are not good signs for the sector. Because I know in my office, farmers who sold their lands in and around Devanali about 15-20 years back come back to me with a flashy card and say, sir, I am developing a layout. Where is the core competency? So it is becoming, too much of supply and too many people in this field. Eventually it will compromise on quality, and eventually it could lead to an oversupply, and therefore there could be a kind of a fall in demand. Now, I've also mentioned in my paper, I hope you have the books. This was a straight copy from my father's principles, that there are 4 canons of documentation. Before getting into critical clauses, there are 4 canons of documentation. Factual accuracy. We should always be factually accurate while documenting. There is a famous saying, take care of the facts, law will take care of itself. Please remember this, take care of the facts, law will take care of itself. Second is legal perfection. It should be precise, safe, and secure in conformity with present statutes. Third is precise expression. When I say precise expression, there should be no room for ambiguous statements in a document. In other words, we should go by the dictum, mean what you say and say what you mean. And the last is formal statutory compliance. Now, these are extremely crucial as 4 canons for us to practice and perfect when we start our journey in documentation. Now, my topic given to me was important and critical clauses to be considered while drafting of documents in respect of real estate projects. So when the word real estate projects come in, it obviously means I am confining myself to a documentation of a project, and a project where I would envisage an owner or owners on the one hand and a developer or developers on the other hand. What I've attempted in my article, although in brief, is to give you throw some light on critical clauses in what we call as an area sharing development agreement, then a revenue sharing development agreement. I've taken an example of an apartment project which comes within the confines of the BBMP. Then I've gone into a revenue sharing model. Further on, when we call plotted development, I'm gone into our area share and a revenue share. What are the critical clauses to be known? I've always said and advocated, in fact, my associate Purnima, who's also a very well-established advocate, had bought a book just now, I think from the counter, talking about taxation of joint development agreements. I feel so sad that we CAs, it's authored by 2 chartered accountants, still choose to call it joint development agreement, which I think my father, brother and me have been barking loud and clear everywhere across the country, wherever we have spoken. There's nothing called as a joint development. Gentlemen, please understand, it is a commercial term. It is because of this faulty word used, joint development, that we got into a lot of taxation issues, as you know. Because, as you remember, in the early days, or even now, some advocates with their fancy to please the developers who happen to be their clients used to have a standard preamble recital in the document, whereas the owner, being financially deficient, technically incompetent, approached a reputed developer who had all the virtues like manpower, money power, muscle power, and requested him to take on development the property, to which the developer condescendingly agreed. Therefore, they jointly formed a scheme. This was words we used to use and I have used. I am also guilty. What happened because of this? Income tax taxing you as an AOP, saying you are jointly developing. You yourself say the owner and the builder is jointly developing. Then we got out of that, we started to fine tune to say no. Then what happened? Especially from the what I call Mumbai culture. In fact, when you come, when RERA's topic is going to be talked in the afternoon and tomorrow, I've always say that Mumbai is the basis for a lot of virtues and also basis for a lot of problems in the real estate sector. Even today in Mumbai, if you do what I call as a development agreement, they will insist on the words that possession is delivered to the developer on day one. In spite of being the financial capital of India, in spite of understanding the problems that could cause by showing that possession is delivered, they insist on that word because they feel it gives them a superior right. As you know, because of such words we used, there are two implications. Suppose in Karnataka I say the owner has delivered possession to the developer on the day of signing the agreement. One is your capital gain issue, which will kick in straight away under 247, as you know. The other is your stamp duty could be levied at as highest conveyance rate because it's an agreement with possession. It's not at 2%, it will be levied at 5%. Nobody understands these other aspects. All they want to look at their safety, and they think by mentioning possession is delivered, they are achieving something great. Honestly, they are creating humongous problem for the transaction itself. For example, I remember when CIT versus Dayalu came in, Jairaj's case came in, and then I think Jasbir Singh Sarkari Ashok, if I'm right, in 2000, where they held that, you know, when you do sign a development agreement, it's just a transfer and therefore capital gains kicks in. One of my learned friends, chartered accountant who has now become an advocate, and other top advocates in the country have argued the matter in various courts. But honestly have failed, and now it is almost settled law that on the day you sign a development agreement, unless you're an individual or a HUF, you have to pay the capital gain. But I'm sorry to state, if I read any of those judgments again and again, none of the petitioners' advocates harped on one important aspect which could have solved the issue in favor of the landowner not to pay capital gains on day one. None of them have represented to the courts what I believe, that a development agreement is a pure contingent contract. It depends on the happening or non-happening of several events, including your plan sanction, including your land conversion, including your clearances. So on that ground alone, it is absurd for anybody to say you pay tax on day one on a project which may or may not happen, on an income which you may or may not earn. The sad part is again faulty documentation. Where the courts rightly held was, they say, yes, you have beautifully written in one paragraph, the owner has delivered only permissive possession under 52 of the Easements Act as a license. There is no transfer under 53A. So there is no transfer under 247. It's a mere license to enter upon the property for the limited purpose of construction. And therefore, there is no question of a capital gain accruing. You draft a beautiful clause on top. Somewhere in the same document, we mention, even today, during the course of development, the owner and/or his authorized representatives shall be allowed to enter upon the property for the purpose of carrying out inspection. What a disaster this sentence is. What the court rightly said is, you are asking permission to enter your own property. That means you agree, you concede that you are divested of possession. Therefore 53A kicks in, 247 kicks in. So when we document, we should be so careful in our choice of words. So at least in our office, we have stopped all this kind of expressions used in a document. But as chartered accountants or maybe a few advocates, it's my humble request, let us not get into these kind of documents to please somebody. Avoid legal jargon. You should be very, like I said, a document should read like a nursery rhyme. Because I have always say, you use the word successors, heirs, administrators, executors, assigns blindly. Why was it used? Because if I as an owner am buying a property, It's not for me, it's for my generations to come. None of us would like our grandchildren to get up one day and say, what the hell did my grandfather leave behind? I don't understand the language. And we advocates have this fad or this fancy to start our documents with, our GPAs. Know ye men, these presents, I constitute, appoint and nominate thou. Because we think it's a great favor we are doing. It's a disgrace. Absolutely, because end of the day nobody understands what it means. All I can say is I am appointing you as my attorney. And the same thing, like I said, in your development agreements we find all kinds of legal jargon. The new fancy I have seen, especially among some senior advocates, which is shocking. They make it so painful to read a document. Other day I read a document, subject to the owner complying with all the obligations set out in para 3 supra, read with the compliances to be observed by the owner under para 10 infra, and subject to all clearances and sanctions obtained for the project under para 27 infra, XYZ. So to read one paragraph, you will have to refer to the document running up and down. I don't know who has caught this fancy and why these words are being used. It is so stupid. Each para should be self-contained. That para there should be a full stop, there should be a comma, it should be self-contained. I request all of you to start this practice of, not to use legal jargon, to use simple words which for a common man to understand. In fact, my father and me wrote in the Hindu for 7 long years on property law. Every Saturday a column. After he passed away, we stopped. So we used to reduce the entire property laws to simple English for a common man to understand. That should be goal of a professional. I don't want people to come to my office for me to show my knowledge. I want people to come to my office to ensure that a transaction is recorded properly. The principle was simple. What was taught to me and my brother by my dad when we came to office day one. Protect the transaction and not the parties. Don't protect the bride or the bridegroom, protect the marriage. That is the role of a professional. Not using legal jargon to show your knowledge, not superimposing your legal aspects on a transaction. You should do everything possible in your document itself to make sure that the transaction goes through seamlessly. It should give the least possible room for litigation. As long as each sentence is self-contained, as long as the language is simple, and as long as your dispute resolution which you draft is simple, there should be no room for unambiguity in a document and therefore disputes. Unfortunately, the current trend, especially my brother and me, even last month, we conducted a workshop in the National Law School. There also we felt that most of the youngsters have been taught in such a way, they prefer to use all this jargon because they feel it's a fancy. So we explained to them. In fact, it is embarrassing for us that we were asked to conduct a half-a-day workshop to teach the professors from various schools across the country on how to teach. It was such an embarrassing moment because we didn't know we are not as mature or as intelligent as them. But then I asked all of them one simple question. I said, you take any law, how do you teach a law? So most of them said, sir, definition 1, applicabilities, definition 2, sections, definition A, definition B, definition C. So I asked all of them, do any of you know the importance that reading a section and interpreting it is not the issue? How you have to teach is from first understanding what is the statement of objection reasons. Now RERA is here. For example, you take any law, you will have a statement of objection reasons. Why this law has come about? What was the necessity for this law? What is the purpose of this law? What was the mischief prevailing before this law came? What mischief this law is attempting to remedy? Unless we learn the statement of objection reasons, there's no point jumping into the sections. Surprisingly, they all appreciated us for having said that because I heard that none of them even concentrate on the statement of objection reasons. So this is extremely important. When you look at a document also, like I said, the preamble, we write the Ramayana. We have to write as detailed flow of title as possible. We have to mention from where it started and where it has ended. Now, if you go to, because RERA has come in, my documents here are more RERA focused, taking into account various expressions we use. What we do now is to cover the maximum under the definitions. Purnima, if you can run through the definitions, yeah. Now, RERA, I laud the act, I laud the intent of the act, but unfortunately we still find a lot of ambiguity. We still find the interpretation, the Karnataka rules which are in conflict with the act. We still find certain notifications, certain templates published by the RERA authority which we feel are few and far between. I heard even today they have released some, he was telling me they have released some notification on the allotment letter. However, consciously what we have done is, we have documented the way we have understood RERA. I think more than 100 projects we have documented, and luckily all have been registered with our template being accepted, which honestly is totally contrary to the template published by RERA. So as long as the principles of RERA are fulfilled in your document, I see no reason why we should repeat a template which according to me is not suitable. Correct? Now, if you see the first definition, we have talked about absolute completion. I've gone by alphabet wise. When I talk about absolute completion, let me cover two important aspects. RERA talks about a completion certificate and also an occupancy certificate. Under RERA, completion certificate means when the building is ready, complete, to be, for all purposes, the structure is complete. That means completion certificate. Occupancy certificate means the certificate issued by the statutory authority allowing you to occupy the apartments in a project. Unfortunately, in most cases, even if you complete the project today, by the time you apply for an OC and get an OC, it is a good 1 year, sometimes even 2 years. According to me, although RERA is there to protect the interest of the consumer, in a development agreement scenario, the obligation of the builder towards the landowner ends in terms of compensation for delay the day he achieves practical completion of the project, which I have also defined. What do you mean by practical completion? When the apartments are complete, fit for human inhabitation, and the OC has been applied for, you have achieved practical completion. It's not in your hands if the OC is delayed by 1 year. Therefore, you have to define very clearly what is an absolute completion means. Practical completion plus OC becomes absolute completion, and practical completion means OC has been applied for, building has been completed and fit for human inhabitation. This is very essential for you all to mention as one of the important definitions. Now, RERA talks about sale of carpet area. We have done a departure from the past. In a sense, past we used to send what is called a super built up area. The grouse was, builders were loading 25-30% as super built up area, which couldn't be calculated and taxing the customer. So they said sell carpet area. But when you see the definition of carpet area, it also says it includes your exclusive veranda area, exclusive balcony area, right to use, exclusive balcony area, and excludes common areas. In other words, today, what is conveyed to you is only the area within your 4 walls, which is the carpet area. Please understand. Even the thickness of the wall, your internal balcony at home, you don't own. You have only a right to use, which is concurrent with your right of ownership of the carpet area. It's a big departure from the past. In other words, today if I'm sitting in the balcony within my house, in an evening to chill, I must realize that I don't own it. I'm only a licensee. That is what RERA has reduced my ownership rights to. Secondly, RERA has said the undivided share in the land. Common areas include the land in the project. And they say under conveyance, we have to convey the common areas in the project to an association of allottees. Other words, your entire land is also to be conveyed to an association of allottees. This is a typical Bombay concept. Like I said, RERA was drafted by a Mumbaiker in Mumbai, sitting on a beach, because if you see section 89 and 90, it only talks about repealment of the Maharashtra Housing Board Act. Doesn't talk about repealment of the Karnataka Apartment Association Act. It's a typical Bombay concept from day one, where they said you have only right of possession over your apartment. You are entitled to a share certificate in a cooperative society, which entails you to possession of an apartment in the building. You don't own anything. So here they are again trying to say, land you don't own, you own only a carpet area which is hanging in thin air. Now where my problem with this, with me for this is simple. Take a situation, if there is an earthquake, the building crashes, then what happens? In the old scenario where we used to convey super built-up area along with proportionate undivided share, right, title and interest in the land, each apartment owner became a co-owner with the other apartment owners in the land under a co-ownership basis, which is therefore helped him in a sense. One, it helped him to ensure that other owners do not do an independent development without him, because he owns undivided share. Every inch of the soil there is a percentage he owns. One. Secondly, it gave the freedom for all of them to sit together and come up with a new development. Now, under this scenario, suppose there is an earthquake. The association will be in control of the land. If the association becomes another political or a mini political outfit, and you have groups, one group says I want a mall, other says no, I want just theatres, one says I want a apartment, the third says I want a pool, then what happens? So the very basic safety has been given away under RERA. The second important thing for you to know, now the basic propaganda is, the moment I enter into an agreement under RERA, it has to be registered if I take more than 10%. Do you agree with this? How many of you have a comment on this? RERA says, or the popular perception is, under RERA if I take more than 10% of the sale price, I have to necessarily enter into an agreement with the allottee, and they also say it should be registered. I humbly differ with that. For a simple reason, in the same sentence they say, subject to the local law in force. In Karnataka, an agreement is still not compulsory registrable. A development agreement is not compulsory registrable. A GPA is not compulsory registrable. Therefore, you can enter into an agreement and adequately stamp it, 0.1% subject to 20,000, to ensure that it becomes legal tender and a document which can be submitted as evidence to a court of law under 34A of the Stamp Act, but you need not register. Why I am saying registration could be dangerous? Because most of my friends, I hope my own clients are not here, but everybody does this. They have what is called a soft launch, then they have a hard launch, and then they have a final launch. Now what do you mean by these terms? One is, first day the brochures will come out, they'll call people like this for tea or coffee or high tea and say this is the project where it's called a soft launch. So you take bookings. Most of them, to show that the project is doing well, do in-house bookings. You know what I'm saying. So you assume that I'm a cantankerous realtor. Many of these realtors block units on day one in a project thinking they can make a buck out of it. I will go to one of these launches, I will pay 11% of the consideration, ask the developer to register my agreement, which he will do. Let's assume. Then I stop paying my installments. He will start writing letters to me, demanding me installments. Letter 1, letter 2, third will be a love letter, fourth will be a hate letter. Finally he'll say, I'm going to file a case against you. I'll say, you can do what you want. You know why? Because if he has to resell that apartment, although there's a clause in the contract that he has a right to terminate, etc., etc., the entry in the EC has to be reversed. In the EC, my name is appearing as an agreement holder. Please understand. So till I go to the sub-registrar's office and I execute a cancellation of that agreement and reverse the entry, nobody will buy that apartment. So I end up not only paying him 11%, but then tying his hands up so badly, he ends up paying me at least 20% more for me to get out. It's a very easy thing to do. So none of us have thought, in fact, CREDAI, Ratish said, I'm a member of CREDAI. Ashok and me have always said, I feel CREDAI has done nothing for the industry in addressing critical issues under RERA. honestly speaking. They challenge the constitutional validity. The court said it is constitutional valid. They have not challenged some basic sections, like section 31, complaints. It talks about a voluntary consumer association. Technically speaking, Ganapati Bappa Moria Association in Chembur can file a complaint against a project in Bangalore. You know that? If you read RERA as it is. So it can be misused. Then they talk about insurance on title, which is laughable and ridiculous, at least in this country. I give opinions day in and day out. If any advocate, including my dear friend Vinay and chartered accountants or anybody tells me that there is a 100% accurate title on a property, either he doesn't know his job or is unfit to practice. There cannot be 100% title. There will always be an ambiguity. It's what we do is objective title. In spite of the deficiency, is it marketable? Is it clear? That is the only way. You're asking me to issue a title. For example, in these agricultural lands, when Purnima sends a list asking for the original grant certificate or grant order, or the index of land and revenue extract, they come out with an endorsement saying Shitalavagade. That is, it is lost or it is mutilated. This is the endorsement I get from the government itself. So you are expecting me to insure title when you yourself don't have a record. How can I insure something which you yourself are not sure of? Until recently, now of course, the Tahsildars have started attesting family trees. Till about 4 years back, I always say this. It is a nightmare, even under RERA, to give a flow of title, because I have seen family trees, many of you would have seen. Like I've always said, those days the family trees were drawn up by village accountants, possibly under the influence of alcohol, possibly under the banyan tree, possibly after 6 p.m. Due to illiteracy, I have seen family trees, mother's age 18, daughter's age 15. And boldly they will mention Modalle Henti, Edne Henti in the family tree. Very well knowing about the Hindu Marriage Act, very well knowing that there is an illegitimacy, because that was the literature, that was how literate they were. And they used to forget to write the names of daughters at all in a family tree, because according to the local village laws or the tradition, once a daughter is married, she is no longer part of the family. So only the sons used to be reflected. And we used to include the sons in the sale deed. But then a daughter used to come and file a case. So these kind of situation which we have, asking me to insure title is absurd. Yes, I can guarantee title as clear and marketable. I can indemnify you to the title which I know. I was asking Purnima in the morning, take a will. You have a situation where a person has left a will. It's registered in book 3, as you know. It's not a book 1 document. He dies. The family thinks he has passed away intestate. So they become co-owners and enjoy the property. Later on it is discovered that he had left a will. So by the time the property is sold, what is the fate of the purchaser? Because I can't go and apply for a certified copy of the will. So nobody has an idea and whether a will exists. So what precaution we take? Only precaution we take is we take an affidavit or an undertaking from them that he died intestate, he had no will, and there was no will registered or executed by him. Other than that, there is no method in this madness. So this way, we have to be very clear in our thought process while doing a document. Now, if you see in area sharing model, you have to have, because of this 70% stipulation on putting your money into a bank, the owner also is obliged to follow that. Owner also has to have 70% in a bank. Developers also have to have 70% in the bank. The RERA circular says you should have only one account. But we have said no. It affects the owner's independence. In an area sharing model, owner has a right to have a separate account and a 70% separate dedicated account, because he doesn't want the builder to know what he's doing with his money. If it goes to a common account in an area sharing model, obviously you're depriving the owner, because he has to go to the builder's office every second week for money. So in an area sharing model, we have categorically drafted that you need a dedicated developer's account separate, dedicated owner's account separate. It should be separate only, and definitely RERA is accepting and registering all the projects for which drafts we have done. Now, take if you see definition of a garage under RERA, there's something known as a garage. Garage, as we know, is something which is with a shutter down where you park your vehicle. Now, many people have asked me this question. If you read it, EFG, yeah. Garage means a place within a project having a roof and walls on 3 sides for parking any vehicle, comma, but does not include an unenclosed or uncovered parking space such as open parking areas. Other words, if you read the definition as a layman, you will think that a garage has to have a wall on 3 sides. Because it says garage means a place within a project having a roof and walls on 3 sides. Like the old garages. So the basement, you think, will have to be filled with walls on 3 sides for a car to park. But if you actually read it, what we define is garage means the basement which has walls on 3 sides. Basement also has walls on 3 sides. So when you define words like that, we have to be very careful. Otherwise, they could say it means, sorry, each car parking space has to be enclosed. That is not the intent. Intent is it should be covered by walls on 3 sides. The designated parking area, not necessarily the parking space. Now, when you define saleable area, we should be very careful. It should be carpet area plus right to use and enjoy the internal balcony area, your exclusive veranda area, which right of user run concurrently with your right of ownership of the apartment. So other words, you should create an umbilical cord between the carpet area and your apartments and the super built up area in the document itself, to make sure that tomorrow nobody comes and says it's not, you don't own that balcony, you please sell it to me so I can walk in every day and sit there. So we have to be very careful while defining saleable area. In fact, I have this famous clause of force majeure, and during COVID it became a very fancy term, force majeure. You know, we are also sometimes biased. When we draft for a builder, we include things like lack of availability of cement and steel as a force majeure condition, which is ridiculous. That's your core area. Otherwise, we exclude that when we only say famine, flood, war, COVID, like pandemic situation, etc., etc., etc. Now, apart from that, you should also define that completion depends on legislative enactments or notifications or changes in law which could be an impediment to your development. Because now you had flooding in, say, Vartur. Suddenly they say, okay, next 3 months there's no plan sanction going to be given. For some reason, it's beyond my control. It's not a force majeure condition because that's not an act of nature, but it should be mentioned as separately that even in these circumstances, there's extension of time should be allocated to the developer. Always, I said under RERA, to be on the safer side, if you're looking at completing a project in 2 years, it should be, say, 3 years at least, because otherwise, you know, the penalties, the etc., and what the RERA authority comes after you. The other thing is, deliver the brochure should be far less impressive than the actual product. Understate in your brochure, to the extent of saying, I use red oxide and not marble. Because the penalties are so heavy. But one way it is good, because today, before we had these fancy brochures, but the brochures were 300% better than the product. Now that has stopped because of RERA. People are afraid that, because as you know, the Supreme Court has also said, I think in 2 judgments, Purima, that consumer protection is a concurrent legislation. I can not only come under RERA, I will not only file a complaint under RERA, I can also file an application under the Consumer Protection Act against the builder. And I read one yesterday night, if I stand corrected. They say that even under your, if it's a company, you can approach NCLT because the consumer is a financial creditor. So you have 3 options now to target any erring builder. So all these 3 are open, and RERA has only ensured that there is some regulation in the process. 70% of parking of funds is definitely a good step, which we have also mentioned as a definition as to why, because it does not allow him to divert money to other projects, which was rampant. and also it protects the end customer, because many of them avail whole home loans. Unless they get their project on time, it becomes ridiculous. Now, in a revenue sharing model, apart from the standard clauses, there are 3 critical clauses. You have to define what is distributable income. First, define what is the total project revenue, what is the distributable project revenue, and what is the non-distributable project revenue. Now, why I'm saying, there's something called as pass-through charges. For example, GST, for example, power deposits, water deposits, maintenance deposits, which you collect and pass on. That should not form a part of the distributable revenue at all. It should be parked in a separate account and it should be paid to the statutory authorities. Now, in the early days of RERA, banks were taking a lot of advantage. If 100 rupees was my sale price, and say my deposits, etc., were about 15 rupees, they used to say deposit 70% of your 115 into the account, which we protested and said we cannot be more than 100 because that's a statutory obligation. I have to wait for my architect, chartered accountant and engineer to give a certificate and then pay my statutory obligation, which is going to be penalized. So that is irrational. Now they are finally reconciled to the fact that pass-through charges will not form a part of the 70% which has to be provided for in a kept in a dedicated account. So we have to define what is pass-through charges. You have to define what are additional charges. For example, floor rise charges, location charges. These are additional charges. That will be part of the distributable revenue. Also, you must clearly mention compensation paid for any structural defect or deficiency in construction or development shall not be distributable revenue, it shall be solely debited to the developer's account. Compensation payable for any defect in title to the land will be debited to the owner's account. So we have to define there, even under the definition of promoter, when we define, we say promoter for the purpose of this project means X, the developer for all construction related and development related activities, and Y, the landowner for all matters relating to title. Because remember, title is always landowners, it can never be the builders. So we have to bring in those definitions which are extremely important. Now, on plotted development, same thing, we'll have to define clearly what the total saleable siteable area. Generally it is 55%, 45% has to be relinquished to the authority. And we have to define what is the developer siteable area, owner siteable area, and in revenue share model, we again have to talk about what is revenue, share of revenue for the distributable revenue, the non-distributable revenue, pass-through, etc., etc. Please remember, I would like Ashok also to come and address you all for 5-10 minutes on this structuring we are doing for plotted development. Now there's a hue and cry. Karnataka and I think Gujarat plate authorities have ruled that even on a plotted development there is GST. As you know, marquee spaces which he will say. For me, GST, I would prefer to call it a grey and surreptitious tax. Grey and surreptitious tax. Because by the time you understand, there are two aspects of grey. One is your hair, other the grey areas in the legislation itself. Surreptitious because so many activities of daily life have now come under GST without your knowledge. So, this GST is creating so much of an issue because sale of land there is no GST. But what they are trying to say is, you are putting in infrastructure, you are putting in pipes, you are putting in etc., 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 etc. Therefore, there is a development activity and therefore GST has to be paid. The latest circular now says, you can have a separate infrastructure fee for that and pay GST on that alone. What we are trying to develop now a concept saying, in a revenue sharing in a plotted development, for providing this infrastructure of so and so at its cost, the developer is being given so much title area in the project, vis-a-vis, so that to avoid the inter-sea works contract and other taxes. As you know, you have a works contract issue, you have an unbooked apartments issue. On unbooked apartments today, you have to pay GST. What is unbooked? Nobody knows. It is cooked or uncooked, nobody knows. What most builders do, 5 days before the OC, they make allotment letters in favor of various people saying it is booked to avoid GST. I'm saying internally. So these are various gray areas. GST is such a huge challenge, especially for chartered accountants. And honestly, lawyers don't understand tax. And especially GST, we will never understand. So unless they come to you and do a structuring together, they cannot do a complete comprehensive document. So that's the critical load for chartered accountants to play with the advent of GST. And like I mentioned earlier, capital gains issue. Now, there are also wordings. I've said it before. I saw in one of the books she bought. In a legal document, as chartered accountants, my humble request, do not use the word HUF, which you are so fancied, you use as a fancy. There's nothing called a HUF in my opinion. It's a taxable entity, discovered, developed by chartered accountants and not by law. Hindu law doesn't recognize HUF. Hindu law doesn't say my family is supposed to divide. That's why it's called Hindu undivided family. The presumption is they always want to divide. Hindu law only says Hindu joint family, joint in food, estate and worship. So in your document while defining a Hindu joint family, please refer it as Hindu joint family. As you know, a wife is only a member in a joint family. She's not a co-parsoner. But you can have a HUF for your tax purposes. Husband and wife, one HUF. Father and first son, one more HUF. Father and second son, third HUF. You think it's tax planning. Actually, you're murdering the law. That's why we have created all this mischief now. You know, everybody's claiming rights in a property. So there's nothing called a HUF in a legal document. In your taxation, you do what you want. In a legal document, it's always a Hindu joint family. Please remember that, and please remember to clearly say X is the Karta, his wife is only a member, and so are co-parsoners. Now, who are the co-parsoners? Another important aspect has come. All the judgments on section 6 with no disrespect to women. First they said, what was the question raised? Whether it is prospective or retrospective. Second, whether the father should be alive on the date of the amendment. Third, whether the daughter should be alive on the date of the amendment. Various courts went with various judgments. Finally, Supreme Court has said, living daughter of a living co-parsoner is entitled to. So what does it mean? As long as if living daughter of a living co-parsoner, Bombay said. Supreme Court said living daughter of a co-parsoner, he may be alive or he may be dead. Please understand. So therefore, today a woman gets an independent right who is a daughter. The larger question, does the daughter's children get right? Do they also become co-parsoner? Because son's children get right. Do the daughter's children get right? In my humble opinion, no, even today. Because section 14 of the Hindu Succession Act clearly says, what comes to a woman either by inheritance or device or bequest or in any manner, it comes as a full owner and not as a limited owner. Unless it comes under a will which gives you a life interest. Therefore, there is a conflict which still remains unresolved by the court. What is shocking for me is fine, prospectivity, retrospectivity is well established. It becomes prospective if the legislation is made prospectively. It becomes retrospective if in the legislation itself you say it is retrospective. But this word retroactive they are using nowadays. It beats me at least. At least I have to go back to my English basic classes to understand what you mean by retroactive. Are the courts telling me now, before 2006 where the amendment happened, I should have gone to an astrologer to buy a property and not to an advocate? It is ridiculous. To say right accrues from date of birth, it is retroactive. Because those days when we used to never include daughters in a joint family simply because they were not co-parsoners. Now if you are telling me it accrues from the date of birth, are you trying to suggest those days I should have gone to an astrologer and asked him whether Parliament is going to come out with such a law and done a document? That is definitely not the intention. And I'm sure it will see the light of the day. There will be clarity on this. It has to be only prospective. And it should stop with the daughter. Because section 14 still remains. And there's something called as two-way division as from the tax point of view. When we document, we have to be very careful. You remember old section 6 of the Hindu Succession Act, which is also there as a part of new section 6, which says, when a Hindu male dies intestate, his notional share in a joint family property will devolve by succession among his legal heirs and not by inheritance. Other words, suppose father and two sons, I'm talking about pre-2006 first, they had 1/3 notional share each. If the father dies intestate, his 1/3 share, out of his 1/3 share, his wife gets 1/3, 1/9, sons get 1/3 plus 1/9. So it becomes co-ownership. You understand? So the HUF actually ceases. Supreme Court has said that. Rohington Nariman's judgment is right there with us. But still, the confusion is, in the new section, section 6 as amended, they say, any Hindu, not Hindu male, if he dies intestate, it will go by succession to his heirs. So are you saying literally that the concept of Hindu joint family ceases the moment there is a death in the family? That's what the section means. So we have to be very careful when narrating your flow and telling who has what rights in a property. I've given a list of what you call Purima, those we had made that, no? What precautions you should take before you do a document. There's something called conditions precedent. There's something called as some conditions subsequent. What are generally the conditions precedent? Suppose I'm doing an agricultural land. Nothing stops me from registering a development agreement for agricultural land. But to make it work, to make it fast food from raw food, I have to go through the process of conversion. I have to go through the process of change of land use. I have to go through the process of getting an e-khata. I have to, then only it becomes capable of being developed. So what are the conditions precedent? That the landowner has certain responsibilities towards his title. The builder has certain responsibility to ensure that he is financially capable, the plans are in place, etc., etc. Then what are conditions subsequent? Conditions subsequent is the builder has to perform under the contract in terms of construction. The builder has to pay compensation for delay. The builder should be liable for default to the customer as well as to the owner. For as owner is concerned, the owner should ensure that the title is protected right through the transaction. So you need one paragraph on conditions precedent when you sign a JD where it's an agricultural land where it's yet to become fast food. You have to mention what are the conditions precedent to be fulfilled. And conditions subsequent are those after you sign, which are part of the document which says these obligations have to be adhered to by the developer and the owner basically. Then you have your dispute resolution. Now we are trying to advise people, first go in for mediation. If mediation fails, you go in for an arbitration. If arbitration obviously fails, then you resort to courts of law. So we give options, 4 options in our document at present. Each case it depends on people. Many of them, in some cases I prefer not to use an arbitration clause at all, because it is mischievous. It can allow people to drag the issue. Where I feel time is compliance is the essence of this transaction. I rather avoid the arbitration clause, only give right of specific performance. So these are, I think, a case-to-case basis where we have to look, where we have to see as to what is the actual commercial transaction between two people, how well we should document it. My paper has covered most of the definitions and some critical clauses in the body of the document. How to define owner's area, how to define developer's area, how to define what is called as the dedicated project account, how to define dedicated RERA account, which is 70% of the project account, and mode and manner of distribution also we have mentioned in a revenue sharing. How it should be distributed. You should have a common bank account, there should be a standing instruction that out of the 30% which comes straight away at the root stage itself, it should be distributed in X ratio. The 70% in Y ratio. Now we have an issue, other day we had a very interesting issue. You have bought the land, you are not doing it under a development model. So land cost includes your purchase cost as per RERA, as per guideline value or actual value, whichever is higher. Then they have defined construction cost. So 70% you have to put into an account, whatever comes in. What am I entitled to withdraw? One argument is, no, I can withdraw my entire land cost because I've already incurred on day one. That's what Bombay is allowing, Mumbai is allowing. But Karnataka has rightly said no. The object of RERA is to only use funds proportionate to achievement of milestones. So even if you buy your own land and develop, only to the extent of completion you can withdraw from the land cost and construction cost, which is actually the right approach in our opinion. Now, Ashok, you need about 10 minutes, 10-15 minutes, because I want you to highlight them on this GST issue. Now, I will also take questions because obviously we will not be coming back. From you, before anything else, my paper is pretty detailed. Of course, I have not given you the detailed definitions because it will run into more than 200 pages. You are most welcome to call any of us at any time, because We have always been, have the belief that, knowledge is sharing, knowledge is caring. We learn from you and you learn from us. We have no issues with that at all. And as a part of expression, I've always said this, I'm saying this for the 10th seminar, it's one of my, the favorite incidents my father ever mentioned to me on the use of words. Now you must listen to this carefully. He was a law graduate of 1952 from Pachepas Law College in Madras. It was called as those days Lords of Loyola, Gentlemen of Presidency and Rowdies of Pachepas. But the law department was good in Pachepas. So before that, because of poverty and etc., he used to work in Trichinapalli under a senior counsel as a young boy, basically carry files to the court, come back. All he used to be given is a room to sleep and three meals every day. That's how they survived. He used to tell me the choice of words. He learnt one interesting incident which he actually experienced, a court case where it involved my father's seniors was a barrister educated in England, Brahmin Iyengar, but he was educated in England and had come back. The judge was a British judge. The public prosecutor was also a Britisher, because Trichinapalli was a British cantonment, as you know. And the case was about my father's seniors' clients, 7 of them having urinated against a temple wall. That was they were accused of. They were all arrayed in the witness box. The public prosecutor, in his brilliant English, elaborately, eloquently went on to say, "My lord, this is an open and shut case. It's a criminal conspiracy. There is mens rea. The intention was similar. They have done this with a similar intention to spoil the holy name, to create sacrilege, to create unrest, etc., etc. So open and fit case for conviction, my lord." He went on for about 35 minutes. And before the judge, who happened to be a British gentleman, gave the senior a chance to rebut, he happened to say, "I've heard the public prosecutor, who was eloquently and elaborately brought out the facts of the case. It appears that the similar intention is established. Mens rea is prevalent. And conspiracy among the 7 accused appears to be evident on the face of it. Still, Mr. Iyengar, I will give you just 2 minutes if you want to counter." So the senior got up and said, "My lord, since you have given me only 2 minutes when you gave my colleague 35 minutes to speak, I would rather use those precious 2 minutes to correct your understanding of the English language and that of the public prosecutor." So the judge got angry because he was a British gentleman. "What are you talking to me about English?" He said, "Sorry, my lord, you have to listen to me." Repeatedly during the arguments, the public prosecutor went on saying, "Mens rea, conspiracy, because the intention was similar for all the 7 accused." And you seem to be concurring with his views. My only humble submission, my lord, what are they accused of? Of urination. My humble submission is, urination is a human urge. And the intention was simultaneous and not similar because they happen to get the urge at the same time. So they cannot be mens rea. So your understanding of the English language is wrong. Imagine it was appreciated and the 7 were acquitted. So choice of words is so important in any document. It can change the entire character of a document. Having said this, I'm open to questions. Let Ashok speak for about 5-10 minutes of the GST angle. Then we are both here for the next half an hour. You can ask us whatever you want. Thank you for a patient hearing. I hope you go through the paper. Any doubts you can call.
Adv Raghavan sir to come on the stage and share some of the important aspects of in terms of the taxation relating to the transaction and also some of the impact on the acquisition by the metro trains, metro authority and the BDA, BBMP and the highway authority. A small, sir, please come on the stage, sir, please. Yes, sir. Sir, please. Initially, we have requested Ashok sir to be part of this 2 days program, but he did mention that he is planned to travel to Australia, sir, England, but that's how we have excluded, and it's happy that he's here with us for some time. So I request him to share some of the information or knowledge relating to the transaction and also the acquisition by the authorities. Welcome to Ashok sir.
Ladies and gentlemen, I'll go straight to the subject. I don't want to intrude into the time of Suhail Ahmad, who's the next speaker. But while Arvind kept repeating my name, and I have another good friend of mine who's speaking in the afternoon, Vishnu. Vishnu has specifically WhatsApped me and said you have to cover 2-3 aspects since I heard you are already sitting in that seminar today. I would have loved to be part of the seminar, but like Vinay said 2 months back, I told him I would be in England. Destiny had it that I didn't go to England, and I'm here. I'm more happy being here. Now I'll just go to 2-3 very, very important aspects which I thought I would share with this audience, which is of daily use to all of you. As you know, Arvind and me, thanks to my late father, have always shared our knowledge, never kept it in the cupboard. We have decided that the more we share, the more we care, and more people will care for us. One, Arvind mentioned somewhere in passing a reference that it is settled law that the landowner would have to pay capital gains tax on the date of entering into the development agreement, thanks to the decision of Chaturbuch Dwarkadas Kapadia in 2003 of the Bombay High Court, which then went into a sporadic series of decisions against the landowner, starting with H.B. Jairaj, then Jasbir Singh Sarkaria, T.K. Dayalu, Income Tax Department has been killing all of you. Then we had Ved Prakash Rakra, we had Pramila Krishnan, we have hundreds of decisions against us. I'd like to emphatically tell everybody here today, my late father, when he started dictating his first seminar here, his first workshop, he said, whichever the advocates who argued Dayalu's case, if I get him in front of me, I'll slap him. He said these fellows have disgraced the entire concept of transfer of immovable property. He was under the clear conviction that the possession given to a developer in pursuance to a development agreement is only a permissive possession under a license issued under Section 52 of the Indian Easements Act 1882, and such a possession cannot be considered or construed as a transfer in part performance of the nature referred to in Section 53 of the Transfer of Property Act, and therefore Section 2(47)(5) does not apply. This he argued many times. And right from the time my clients were hit with Dayalu, we were obstinate. We said, we will take you head on till the cows come home. We will not allow a single landowner from our office to pay tax based on that Dayalu judgment. Whereas some of my chartered accountant colleagues and advocates said, no, please go ahead and pay tax as per Dayalu, because that's the best way forward. But we said, never we will accept this. Thanks to what my father taught me and what he said in 2001, 20 years ahead, the decision of CIT versus Sheshasai Steel's Supreme Court 2020 December, pronounced by Sri Rohington Nariman, has repeated the golden words of my late father. He has clearly said, permission given to a developer is only a permissive possession. The concept under 53A is the legal concept. It cannot be imported mutatis mutatis into the Income Tax Act. Therefore, a possession given to a developer is not a possession where the landowner loses domain and control of the land. The landowner continues to remain with the land continues to remain with the landowner. Occupation should not be mistaken as a possession. What developer does is only an occupation, it is not a possession in part performance under 53A. The judgment of Sheshasai Steels has therefore fortified our contention from 2001 that Dayalu is a dead law. And I'm repeating today in front of everybody here, Dayalu is a dead law. If anybody is confronted with Dayalu, please come to me. I will put Dayalu to the cleaners for all of you. Nothing to worry about Dayalu anymore. The judgment of Sheshasai Steels has also been followed by the two Bangalore Tribunal decisions recently. One in the case of N.A. Harris, who is infamous for something else, and one more in the case of G. Balu Reddy. Both Bangalore Tribunal has followed the decisions of Sheshasai Steels and said that Dayalu is no longer a good law. So do not worry about the ghost of Dayalu. It is definitely buried according to me. Point one. Point two. Very interestingly, I fought a case recently. I'm privileged to say that we knocked off 250 crores of tax demand on a revenue sharing development agreement, where as usual we represented the landowners. And very big developer, very big landowner, the department took a contention based on various clauses that the landowner should also follow the percentage of completion method for accounting his revenue share. Therefore, since the developers followed the percentage of completion method, the revenue share received by the landowner, which we had treated as a liability at our balance sheet, they said that should have been taken as income and offered by the landowner based on a percentage of completion method. The landowner has done activity which is akin to what a developer is doing. He is also, the revenue share arises both from the construction and the land, therefore he also should follow percentage of completion method. I wrote a thesis. I got 2 orders. I didn't say I got 2 orders. I managed to convince the 2 earlier assessing officers in a scrutiny assessment that this percentage of completion doesn't apply to me, which was beautifully, written in those orders. The client had a search. I was called at 2:30 at night by the department to explain what this transaction is about. I vehemently argued that I'm not going to accept your contention that the landowner is equal to a developer. They forced my client to accept a particular addition. We got it retracted within 2 months of that addition. Then we fought the battle. They said the officer level, they went against us. They added 600 crores of 250 crores worth of tax, which was the revenue share up to that particular day in 3 assessment years. We challenged it before the Commissioner Appeals. The great learned Commissioner Appeals, anybody will know who it is because I don't want to name him, without giving us an opportunity of being heard, said that the notice given to me for the appeal itself is an opportunity of being heard. Since you did not come, he passed an ex parte order against us and upheld the contention of the assisting officer that the landowner should also follow the percentage of completion method. We went to the tribunal. We asked for an early hearing. They said, why early hearing? We convinced them that otherwise it's operation successful, patient dead. Because I have to pay earlier 20% of the tax, now 100% of the demand for income according to me which is not accrued or earned in those assessment years. Because we had offered that subsequently in the next 3 assessment years. So we went back to the concept of double taxation, etc. Bachulal Kapoor, everybody knows all those things. In a 151-page judgment on 14 November 2022, maybe 15-20 days back, we have got it in our favor, quashing the entire order of both the Commissioner Appeals and the assisting officer, clearly stating that the landowner cannot be equated to a developer. The landowner can follow his own method for recognizing revenue. The landowner can declare his revenue only when the risks and rewards of ownership are transferred, as stated in AS9. AS7 has got no applicability. ICDS3 has got no applicability, and therefore this particular judgment can be used by all, which has got about, we have quoted maybe about 70-80 case laws, and he has literally cut and pasted them in the judgment. And we have said, right from Bilahari investments, etc., we have said, and therefore this is one case law which is going to help the fraternity at large when they are talking about landowners and revenue share. That is the reason in our agreements, what we draft in our office, we put in a clause that revenue share from the landowner is in essence for transfer of 100% right, title and interest in the land. Revenue share of the developer is in essence for transfer of right, title and interest in the superstructure. Because in India, the concept of dual ownership is permitted. If these type of wordings are not there in your development agreement, you would not have been successful the way we were. Because one more clause we wrote in this development agreement, we said very clearly that permission given to a developer is only a permissive possession under 52 of the Easements Act. It cannot be considered as a transfer. And we added one sentence saying that the legal possession, domain and control continues to vest with the landowner till the same is transferred in undivided share to the purchasers of the units in the project. Now luckily the tribunal has quoted that particular paragraph which engineered by the one and only myself, and clearly stated that because of that clause, we also hold that the landowner is not to be treated equivalent to a developer. So this is one more thing I wanted to add. Now Vishnumurthy has texted me while I was sitting there. I don't know who told him I've already come to the seminar. He said you cover 1 or 2 aspects which you are not covered in the afternoon. He told me to cover about the land compensation, metro land compensation, NHB road widening land compensation, whether it's taxable or not. What is the view you are taking in your office? Here again I would like to say, I've done a very practical approach and I've already won at 2 levels in my own client's case. Whatever I'm talking, Trishul Biltech is my own client. Similarly, what I won again in this compensation matter is my own client. Now, the revenue has been taking a view that compensation received under the right to fair compensation, transparency in land acquisition, rehabilitation and resettlement act of 2013 is not covered by the circular number 36 of 2016 of the CBDT, because the compensation is not determined under that act. It is determined under the either the KIDB Act section 28 or the National Highways Act, etc. And therefore they have been taking a contention that this is fully taxable. So I took a contention that going back to why the act, that is your right to fair compensation, transparency in settlement and rehabilitation regulation act, why that came into force, that was a precursor of the Land Acquisition Act of 1994. And I also went into the basic provisions, and I clearly gave a detailed note that even though the compensation is determined under the acts, under those acts, the compensation is payable only under the Right to Fair Compensation and Regulation Act. Therefore, I quoted section 96 of this act to say that there is no income tax or no stamp duty, and therefore I managed to win at two levels that this is not taxable. Now, you may be confronted by the officer saying that under section 105 of that particular act, there is a clear 105(1) says that the compensation which is given under acts which are mentioned in Schedule 6 of that particular act are not covered, and therefore whatever compensation is received under those Schedule 6 acts, which includes metro, is therefore taxable. That the Revenue Authority has not taken the cognizance of the fact that 105(3) of the same act, the government was given the right to issue a notification to remove difficulties. Therefore, under 105(3) of the act, there's a removal of difficulties order passed, wherein they said that all the acts which are there under Schedule 6 are liable to be exempt in case compensation is given under those particular acts. Therefore, in my opinion, based on my own practice, and I've also got a letter from KIDB to this effect, that even though the compensation is determined by us under 28(4) and 29(1) of that act, the payment is made under the RFCT LLAR Act of 2013. So in my opinion, I'm emphatic about my view that it is not taxable. The next issue revenue can tell you is, but we are going to deduct TDS of 10% under 194 LA, and they are deducting 10%. So because we deduct TDS, there's a presumption it is income. Just because you deduct TDS, there's no presumption it's an income. TDS can be deducted even, for example, you're drawing more than 1 crore in cash. They have asked us to deduct TDS. Does it become an income? Answer is no. So just because somebody deducts TDS, it doesn't mean there's an income. Second thing is there's an explanation proviso to section 194 LA, which clearly states that TDS need not be deducted where the compensation is paid under the RCFT LLAR Act of 2013. So even on that account, I'm very clear that you can confront the revenue on this matter. Last but not the least, since I can keep talking till 7 o'clock, that's not an issue. But we have another speaker waiting for us, much more probably better than what I could ever deliver. So on plotted development, my brother was mentioning something about GST. Here we have to again be very clear about our concepts. Two types of plotted development. One, plotted development on own land, which is owned by the particular landowner who now becomes the promoter, who develops his own land into a residential plotted development without villa. He just gives you plain sites. One category. Second category, person developing his own land with plots and villa together, sells it as composite. Third category, they develop a plotted residential development through a development agreement model, not joint development agreement model, wherein the developer is given X number of developed sites to sell as in compensation for the amount he has put into the development, or he is given X percentage of revenue share for what he has given, he has spent on the project. That is the third category. Category 1, where I develop my own land and I developed only plots, and 45% of that land is already relinquished to the local authority. under the Karnataka Town and Country Planning Act by the mandate of law, and what all I develop, roads, culverts, etc., is on that common area only, which I have relinquished to the local authority. And what I do inside a plot, except giving a flowery, a pamphlet that I'm going to have 2 fruit trees, 2 guava trees, etc., which will never be planted. Except for those things, I do not develop anything within the precincts of the plot. The plot is an empty, vacant residential plot. What I develop is outside the precincts of that plot, except for a small chamber which removes the sewage and the water outside the particular plot. Other than that, there's nothing within the plot. Please understand the concept. Therefore, in my opinion, the best way of doing this is, if the site is being sold for 3,000, take 2,500 for sale of vacant, undeveloped residential plot. Take 500 rupees as an infrastructure fee for development of common areas relinquished to the local authority, and charge GST only on 500 rupees. And on that 500 rupees again take the entire input, because even the subcontractors only develop the common area, they have not developed the plot. Now somebody may come up and say, recently one circular has come, sir, August 3rd of 2022, which states that no need of GST on plotted development. Please read that circular again and again. It's only going to lead you into further problems. Because circular says that electricity, drainage lines, etc., which is provided in the saleable area is not taxable. Please remember, you cannot sell the common area, it's already relinquished to a local authority. You are selling only the plot. So in my opinion, in spite of the circular of August 3rd, 2022, you will have to charge GST on a small portion of infrastructure fee, and the balance should be sale of undeveloped, vacant, residential plot. Please remember the wording very clearly. Now when it comes to the development agreement model, please remember that marquee spaces, decision of the advanced ruling authority, said that whatever revenue share you are getting for a developer, he has to pay GST on the entire thing, because that is the compensation he is getting for services rendered for developing the project. Marquee spaces are also upheld by the appellate advanced ruling authority in Karnataka. Deepesh Kumar Gandhi of Gujarat said, what you are developing is developed plots. The character of land itself is changed. Therefore, the entire plot is subject to GST. Right? So, in my opinion, you have to be careful about these things. When you're doing a development agreement, either in revenue share or area share basis for a plotted development concept, marquee spaces is going to squarely apply. You have to ensure that the developer is going to charge GST not on the landowner, but on the end buyer by way of an infrastructure fee, which is squarely permissible in law. So, with these few words, I've taken about 10 minutes, but I thought I want to share these 3 important critical aspects for this audience today. I would love to be part of the seminar, but destiny prevented me otherwise. Thanks again, Vinay, for the opportunity.
Thank you, sir. Thank you, Ashok, for explaining the taxation and the transaction, sir. Friends, any questions to Arvind, sir, relating to the documentation or structuring of the transaction? You can free to ask the question. If you have any question related to the taxation, please retain it. We'll take it in the second half. Questions related to Arvind, sir, on the documentation and legal aspects. Yeah, Mike, please.
There are 2 different models, Bombay model and Karnataka model. In Bombay model, there is a Karme, and in Karnataka model, UDS.
Sir. Society model, and sir, we'll give the mic. Sir, you can start.
See, in Mumbai, the concept has always been the lands are owned by a society. Now you want to actually purchase an apartment. You will be allotted shares in that society, and the shares will entail you and come along with a bundle of rights, which includes the right to possession of a particular square feet of apartment bearing number so and so and so and so floor, as long as you are a shareholder. So land is held by the society. You are entitled to only perpetual possession as long as you are a shareholder in that society. That is the Bombay concept. Now, RERA has almost identical to that concept in the sense they say the land has to be conveyed to an association. So association basically owns the land. And you are entitled, but under RERA the distinction they made is you are entitled to own the carpet area, not only right of possession. So Bombay is pure right of possession. Under RERA it is right of ownership, but only of the built up area.
Sir, in case of land, you call it UDS. In case maybe building becomes old and if you go for redevelopment or sort of thing, at that time municipal authorities or maybe sanctioning authorities ask for the land in your name.
Sir, it's like this. You are entitled to a kata. Your kata will talk about your built-up area of carpet plus your undivided share in land. You are a co-owner of the property along with several other apartment owners. So if you are going for a redevelopment, ideally all the co-owners have to be party to the plan sanction. You understand? I can't exclude even a single person. That's what you mean by undivided share.
All UDS owners should again convey it in a common entity.
Need not convey. They can jointly apply for a plan also.
Municipal
But now under RERA, the association will apply for a plan.
Okay.
Redevelopment plan.
No. Some people are getting confused. Maybe UDS is already conveyed to the individual owners, and again there is no question.
Now question of conveying the UDS to the owner doesn't arise. It has to be conveyed to an association. Now the word used is convey. Please understand. Conveyance is different from sale. Please understand. Conveyance means passing over, handing over. So what we are doing, there is an element of double stamp duty which can be involved. I'll tell you how. When I go to the sub-registrar to register an apartment, he is going to register a composite guideline value which includes the value of the land. So I've already paid 6.6% with registration fee on the apartment. When I'm conveying to an association through a document called deed of transfer, for example, there's no exemption under the Stamp Act. They may still say you pay stamp duty on the entire land. So there is a problem here. That problem still remains unresolved. But what we are doing, in case of apartments at least, we are taking benefit of the provisions of the Karnataka Apartment Ownership Act to say, a deed of declaration under that act, which is going to be registered with the sub-registrar for 100 rupees, is a conveyance of the common areas under the old Karnataka Apartment Ownership Act. So 100 rupees is all I will pay on the deed of declaration. And that fulfills my requirement of conveyance to the association under RERA. But for commercial, it's still a blind area because that act doesn't apply to commercial property. See, interestingly, many of us should know this. You have RERA, but Karnataka Housing and Regulation Act of 1972, Apartment Ownership Act of 1972 is also there.
COFA.
There is a conflict here. Under Article 254 of the Constitution, if you see, there are two subsections. Section 1 says, law made by the Parliament will supersede all other laws. All other laws, state laws. Section 2 says, 254(2), if a state law obtains the assent of the President of India, not just the Governor, the President of India, state law will supersede the central law. That's why you had special acts like Section 6A of the Karnataka Hindu Succession Act, Section 6B, which were particular for my state alone. Please understand. In such a case, technically today, as I said, Karnataka Apartment Ownership Act also exists. I can't ignore it because it has got the assent of the President of India. So I use that as an advantage in residential apartments. But in other cases, definitely there's a twilight zone because there's no stamp duty exemption.
Arvind sir, the confusion is about Section 17 of the RERA Act talks about conveyance of the common area to the association. Yes. The definition of common area includes the entire project land. So that is the confusion we have it.
Yes.
And also we have a concept of undivided share to be registered in the name of the individual owners of the apartment, unless in the Maharashtra it's a society model.
Yeah.
So there is a lot of confusion.
No, what we are doing, Vinay, what I am writing is, we are conveying and selling X amount of carpet area to you, along with X square feet of balcony area lying appurtenant to that carpet area, X square feet of veranda area lying appurtenant to the car, along with proportionate undivided share, right, title and common areas, including the land, which is to be conveyed to an association as mandated under RERA.
Perfect,
That's
sir.
what I am writing.
Yeah, so
To
but-
say that I have a proportionate share, but because RERA mandates, I am conveying.
Exactly, but what our friend's question is in terms of a redevelopment, my khata is in the name of the individual customer.
Absolutely, all the individuals will have to apply.
Exactly. Now the question is, sir, in case of a redevelopment, all these individual customers collectively assign this right to the developer. So all these individuals become the owners, co-owners of the land, and developer will do the development, and the plan sanction would be obtained in the name of the developer, sir. There is no other
Yeah, but
way.
in the
other
case
than
of
at this
completed
point of
projects,
time.
15 years down the line, 20 years down the line, the developers disappeared. All the owners will have to jointly apply.
Because in the revenue record or municipal record, it will not be in the name of the association. Of course, representations are made to the IGR department by industry experts and also professionals, including we also made a representation to have some separate instrument to convey and have a separate entry for the purpose of registration. But our government has to take a decision on that. So time to come, we can expect the answer to this in terms of changes of in the municipal records or the revenue records.
You must always remember, like Vinay rightly said, the sub-registrar's job is to stamp an instrument, not a document. A sub-registrar is a glorified revenue collecting servant of the government. His job is to identify the executants. His job is to identify that they are the proper persons with their Aadhaar card or whatever, etc., etc. His job is to collect the stamp duty on the instrument, not the document. Remember, a sub-registrar does not certify your title by registering an instrument. His job is only that of a glorified revenue collecting clerk. That's why there is a problem now where they have represented to the IGR. I hope good sense prevails and they exempt such a document from being first stamp duty and registration fee. Or they amend the guideline value book to differentiate like those days between undivided share of land and a built-up area, which they won't do.
Fine, sir. Thank you, sir. And the interest of the time, participants, you can ask the question to Mr. Arvind, sir, during your tea break. Sir is around with us for some more time. So I request you to meet him and also get clarified in the interest of the time. And the next speaker is available here to take the next session. Thank you so much, sir. Arvind, sir, and Ashok, sir. It's our privilege, both of you be on the stage. I request the MC members to hand over a small memento. Sir. Yes, sir. So I request the chairman and also MC members to honor the speakers of the morning session. Friends, we'll take a small...
A substitute should never get a memento. That's my strong feeling.
Sir, please. You are not a substitute, sir. You are a main player, sir. Okay. Always, for your information, the legacy of Bangalore branch hosting the real estate conference is always from the Raghavan sir office. The days of NCS Raghavan sir, the father of Arvind and Ashok Raghavan sir, and we are only the facilitators for us. And whenever there is a real estate programs, the first call will go to Arvind sir office and Ashok sir office for their blessings, including this program also. So that is the first call and the origin of any real estate program from the branch. Thank you so much.